You've probably heard of both living trusts and wills, but have you ever contemplated what makes them unique? As you can imagine, there are plenty of nuance in the two common vehicles for transferring property and assets to an heir, and each has its own specific advantages to those who use them. In fact, understanding the distinctions between each and their common uses can be a valuable token of knowledge for you and your family. So, which might be best suited for you and your family's future? Let's review a few key differences between a will and a trust. First, what is a will? A will is a legal document that outlines your wishes in the event of your death. It can declare everything from whom you wish to care for your children to how your assets will be distributed among family and friends. A will can declare how you wish to be cared for if you are incapacitated. The purpose of a will is to organize a person's estate so that it can be passed on to predetermined heirs, most often family, and not the state or just automatically to the next of kin. In essence, it gives you control over your belongings, your property, finances, and more once you have passed away. 2. What is a trust? A trust is another vehicle used for transferring property or assets, only this time the trust is used to declare a person or institution known as a trustee, who is employed to hold the property in place for the beneficiary over a determined amount of time. For example, a person decides he would like to pass on an inheritance to his grandson, who is still a child. By establishing a trust, he can employ the parents as trustees who will maintain and secure whatever assets are being inherited until his grandson is an adult. The key differences between wills and trusts. Wills and trusts each have their own benefits to those who employ them, but there are some key differences for each that can make one more preferred than the other, depending on your individual needs. For example, a will passes through probate. Wills typically pass through a process known as probate, a procedure in which a court ultimately gives permission for the assets in a will to be passed on to their heirs. There are, however, ways in which probate can be avoided with some planning and preparation, or depending on state law. Wills only go into effect after death. Since a will's primary purpose is to declare how a person's wishes will be carried out after their death, the document obviously doesn't take into effect until then, or until the owner of the will is incapacitated. A will is a document that directs who will receive your property at your death and appoints a legal representative to carry out your wishes. Trusts take effect immediately. Property can be distributed before death, at death, or afterward as determined in the trust itself. Each covers different types of properties. A will only covers the specific property a person owns, in their name only, at the time of their death. A trust, on the other hand, governs all property it's been funded with, such as insurance policies, for example. Now, how about some of the direct comparisons between both? For example, wills can be used to appoint a guardian for a minor, while a trust can't be used to appoint guardians for minors. A conservatorship may be avoided in a will with a durable power of attorney, which allows you to appoint a person of preference to handle your finances in the event that you become incapacitated. A trust, however, automatically avoids a conservatorship. The successor trustee that you appoint will be responsible for transferring your property. We're eForms, the biggest online database of legal documents. We've got even more information about wills and trusts at the link below this video. So click the link and don't forget to subscribe for more weekly videos.